Yes.
May I tell? My lord, in respect of item number 8, my lord, supply, my lord, yesterday, my lord, we file an additional affidavit that is not on record. So let it be being on record.
Bring it on record.
Yes.
Yes.
May I please, Your Lordship? I beg to mention listing of WPC for withdrawal for tomorrow, Lordship.
May I please, Your Lordship? I beg to mention for listing one IA, Lordship, for vacating a stay order.
Have you filed the IA?
Yes, Lordship.
Has the IA been filed?
Yes, Lordship.
When?
Lordship, it was 10/10/2023.
Friday.
Okay.
Friday.
May I please, Your Lordship? I'm praying for a listing for a contempt case matter.
Contempt case.
Yes,
Fresh matter or old matter?
matter. No, not the case.
Old matter.
Yes.
On Friday. In view of the submissions made by the Lord, that does not wish to press the matter, needed petition with the vendors that dismissed withdraw. Interim orders, if any, stipulated pending IAs are also dismissed.
Yeah, please.
Yes.
Kindly, Madam, notice 20 issued to new incumbent, that is, response number 6, the Ravi Kota, the Chief Secretary to the Government of Assam, my lord. And response number 7, Chief Bhaskar Viti Sharma, the Chief Engineer, Water Resources Department, my lord.
You have arrayed them as parties.
Yes, my
So
lord.
notice will have to go.
Yes, my lord.
Heard MSD Surma, pursuant to orders passed by the court, respondents 6 and 7 have been arrayed as respondents. Accordingly, read notice they issued to respondents 6 and 7. Return over after 4 weeks. The petitioner will take steps by usual courts and registered court within a period of 1 week from today. Mr. A. Das appears for
Response number 1, Your Lord. The earlier Chief Secretary.
Mr. S. Dr. for
Number 5.
respondent number 5, Mr. Pegu for respondent 3. Anyone else?
My lord, allow me for dusty service, my lord.
Dusty is also permitted
Oblige, Your Lord.
to be routed through the registry of the court.
On the last occasion, you also directed the respondent to find out whether any fresh materials were there after the inquiry.
Yes,
Lordship, we have received the records today morning itself, so we need some time to go through the record.
In fact, from the so-called notice itself, you also find that no fresh material, they are completed on the basis of the earlier materials only. They mentioned there.
how much time do you require?
Day after tomorrow.
Day after tomorrow. That is on Thursday. All right, Thursday. Thursday.
Interim may continue.
Interim order passed earlier will continue. It is submitted. That I think out. But, right.
The additional affidavit has not come in that matter. Can it be taken at some, I remember some case, madam. Item 8 motion, madam.
So what is required to be done here? It has already been deposited, everything is done. Now you go under the provisions of the act.
Madam, I have submitted to arbitrator, my also. They are also not doing anything.
No, arbitrator is already appointed.
Already appointed, so if he can dispose the matter, that can do also.
Who's the arbitrator?
Arbitration is the, I have all, earlier also I have given the copy.
Some
That's
secretary.
special secretary.
Second, second.
Special.
Lordship, they have approached the arbitrator will decide. If he is
Yes,
not,
we have
satisfied-
also submitted before him also, madam.
yes, let the arbitrator decide.
Not petition.
not yet.
If that is there, I need some accommodation, otherwise, my, that's,
Accommodation.
if additional affidavit is required, madam, that is why I'm saying.
We don't know, you have filed it, you tell us.
Yes,
whether
I
it
felt,
is
if
required
that
or not.
was, that may not be.
Who has filed the additional affidavit?
We have. filed.
So you have to tell us whether it is required or not.
No, madam, if that is the, madam, that issue can be done. If arbitrator goes and finalize the matter, that will do.
Yes.
The additional affidavit. You
Arbitrator-
give us a copy, let us go through. If you have a copy of the additional affidavit. What have you stated here in the additional affidavit?
That I have, that representation arbitrator.
Arbitrator official, the official আর কি pendency থাকে ওটাই কি বলি
Page 181, madam, we have filed before the arbitrator.
It is already there, it has been filed. Who represents the special secretary, government of Assam?
revenue.
Revenue. Please find out if the this application has been filed.
28-6,
This is an application, you have to file an,
yes,
to file an for arbitration.
under section 3G5.
National Highway Act.
National Highway Act.
সেখানে রেভিনিউ কপি তো আছে
May I send over, madam?
ফটো আছে অলরেডি ফটো আছে
May-
স্পেশাল
Yeah, I will.
সকলে রিপ্রেজেন্ট করে
Yes.
লাগে নাকি মিঠা বলে
3G5, madam.
not satisfied.
Yes, it has been filed.
Madam, basic question.
Who's the counsel for special secretary? You get instructions
Lordship, I know.
whether it has been received or not, or any orders have been passed?
No.
When can you get it? By during the course of the day or tomorrow?
Lordship may allow one day time.
Tomorrow,
Yeah,
on
Day after
Thursday,
tomorrow, Lordship.
on Thursday, okay. Third, Mr. H.R.A. Chaudhary, Learner Senior Counsel. MS, also heard for HIPL, Ms. G. Hazarika for Revenue Department, H. Sharma for
Number 5 and
five. The petitioners have filed an additional affidavit today. It has been brought on record today to, and reference, and it is submitted by referring to the state legislature that in terms of provision of section 3G within bracket 5, since the petitioner is aggrieved by the compensation amount
Awarded by
issued by the, determined by the competent authority, an application has been filed by the petitioner before the special secretary, the government of Assam, who has been notified to be the arbitrator, who has been notified by the central government to be the arbitrator. So, in terms of the said provisions of section 3G5, the arbitrator has to decide the question. The arbitrator appointed so will determine the grievances of the petitioner raised by way of by filing an application under the said section 3G5. So, learned revenue counsel for the revenue department is not posted with his instructions and has prayed for a day's time. Accordingly, let the matter be listed on Thursday, on which date the standing counsel for the revenue department.
Friday.
They have got the stay order, Lordship, yes.
No problem, my, over, no problem.
Lordship, what is this?
To determine whether steps have been taken by the arbitrator to dispose of the representations stated to have been filed by the writ petitioner under section 3E5 of the NHA. Based on Thursday. Yes, uh-huh. Yes,
Matter may be taken up after some time, I see
you argue the matter. What is the matter? Fixed for hearing.
Your Lordship, the penalty order of the against the petitioner was reviewed suo moto by the respondent going to see your Lordship. Matter may time may be taken up after some time.
Yes, Mr. Tribal.
In fact, my lord, your lordship, at the matter, a review. My lord, they say that it was time barred. But in fact, my lord, as per the provision, my lord, it is to initiate it. So it is within time, my lord. The lordship may just see. My lord, the main order, the Disney Authority order is at the Annexure M, my lord. Which is at 112.
Yes,
Now it is on 12/9/2014.
Yes.
And initiation of review is at page 114.
No, what is 112 is
My lord,
the
provision for,
punishment.
yes, the provision is for 6 months.
Where is that provision?
I will just. They have also quoted, my lord, same at page 14. Yeah, but I'm just giving the page of the paper.
Page 14.
My lord,
Page 14.
page 14, they have quoted. Provided no action under this rule shall be initiated. That is the main word, my lord. Initiated more than 6 months after the date of the order. So initiation, my lord, that's not final order. So initiation order is at page 114. Final order is later on. Final order may be, my lord, after some time. Because a so-called notice is to be given to them. Final order is at page, my lord, 126. Exactly. So as per them, my lord, that the order should be passed within 6 months. It is not fair.
So the order of punishment is at page 112.
Yes, page 112. Well, the charge is very serious, my lord. He has issued tender, false newspaper cutting, my lord, forgery. He has kept it and then given it to somebody, my lord. No paper publication was there for newspaper. So that is why, my lord, the reviewing authority has reviewed the order. Charge is very serious.
Yes.
So it was, my lord, originally it was reduction of 2 stages lower time scale. Now, my lord, the dismissal order has been passed by the reviewing authority. He is the appellate authority, he has the power of review.
Yes. Yes.
Your Lordship, my senior is say
His way.
personal. He had certain personal urgency, Your Lordship, because of which. Your Lordship, my senior had earlier argued in the matter that the second penalty
You answer
order
the
was.
question in terms of the rule. The rule says shall not be initiated. Yes. So it was initiated within 6 months.
6 months.
Your Lordship, our contention is that it was initiated beyond the 6 months.
Go on. How? On the date.
They took another ground at double penalty. That is also not correct.
Was the ground.
Your Lordship, the initial order of penalty that was passed on 12th of September 2014. However, the enhanced penalty was sought to be imposed was issued on 20th of March 2015.
No, no,
By
no,
the time already 6
no,
months and
the-
9 days had elapsed, Your
no,
Honor.
no, no, that is the final order.
Final order.
114 is the order by which they decided to review,
Yes, Your Honor.
which indicates that they initiated. They initiated this on March 9th.
March 9. Your Lordship, my senior would argue on this point, Your Lordship. Yet,
The matter is called up, we are required to take a call.
Your Lordship,
You know, this is a matter which is listed, fixed,
some personal urgency, Your Lordship, passed over for the time being.
and you should have made a mention at 10:30.
Urgency, Your Lordship, because we hadn't anticipated the same, Your Lordship.
As submitted by a council. Your name, please,
See that's, Your Lordship.
MS
See that's.
C. Das. That the arguing counsel, Mr. P. Monto, is not unavailable in court. The matter stands adjourned. Mr. G. N. Sahiwala is for the respondents.
Your Lordship, in this matter, I have been led by Mr. Rohan Shah. He's a counsel from Bombay. He'll be appearing online to BC. Your Lordship, he currently is on legs in some other course. Your Lordship, if Your Lordship may kindly take it up at 2 p.m. Your Lordship.
Not
If it is
doing-
possible.
What is the issue about?
The issue is otherwise relating to issuance of proposed notice without the jurisdiction.
Mhm.
Issuance of proposed notice without the fence jurisdiction at assessing of. My learned friend, Mr. KL, is appearing for the GST. He is also not there. So,
Is not there, what can be done? You got it fixed.
document and take it up on next Thursday, 25th.
We're not fixing a date. I don't see why this matter is given out of turn hearing. Come for part two list.
Otherwise, it was, there's the interim order play, you know, that's why.
You're enjoying the interim order. You enjoy the interim order. Stopping. Why do you say there is no jurisdiction?
Lordship, my learned friend will be able to.
Section 61 of the GST Act says that before any inquiry or any proceeding, a informed GST ASMT 10 is required to be issued. That has not happened in the present case, and that is also recorded and admitted by the respondents, and it is also recorded in the interim order. My lord, so please come to para 8 of the interim order, page 6.
Interim order dated?
Interim order dated 13 December 2023.
Para?
Yeah. Para is para 8. It begins at page 5. The relevant portion is at page 6. At the bottom of the page.
Hmm.
Para 8 begins at the bottom. In the very next page, fourth line from the top. It has, however, been admitted that Form GST ASMT 10 was not issued by the. This is the what was submitted by the respondent.
And what is the provisions of the act?
My lords, may come to page 164 once. Page 164 of the writ petition. That is the provision of the act. That is section 61. My lord, the show cause notice is emanating to give you a brief background. Is emanating on the basis of a scrutiny. Section 61 deals with scrutiny of returns.
Hmm.
My lord, has that page 164.
Yes.
My lord, provision 1. The proper officer will scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed, if any, in such manner as may be prescribed, and seek his explanation thereto. In case the explanation is found acceptable, the registered person shall be informed accordingly and no further action can be taken. 3. In case no satisfactory explanation is furnished within a period of 30 days of being informed, the proper officer for such period as may be permitted by him, after accepting such discrepancies, fails to take the corrective measure, the proper officer may initiate appropriate action, including under 65, 66, 67, which deals with audit, special audit, investigation, and the. Now, to turn the page 165, which is the rules. Prescribed under the GST Act means prescribed by way of rules. Rule 1 and Rule 99(1), where any return furnished by a registered person is selected for scrutiny, the proper officer shall scrutinize the same in accordance with the provisions of Section 61 with reference to the information available with him, and in case of any discrepancy, he shall issue a notice to the said person in Form GST ASMT 10. It is a mandatory provision. Proper officer is required to issue Form GST ASMT 10 in cases of scrutiny to highlight the discrepancy. That has not happened in the present. He has assumed jurisdiction and he has issued the notice directly without following the set procedure of law. My lord knows that in case when a statute, being a creature of the statute, when the statute prescribes a thing to be done in a particular manner, it has to be done in that manner only. And my lord, this is an admitted fact by the respondent, which has been noted in the interim order as well. That Form GST ASMT 10 was not.
Now, what has he issued? Pursuant.
Before coming to the issue, I just also want to show my page 143, which is the communication, just to highlight that ASMT 10 was not issued. The issue, my lords, basically pertains to denial of input tax credit on the ground that my details that was furnished in Form GSTR 9C were not reconciling with Form GSTR 9. From GSTR 9 relates to annual return. GSTR 9C basically relates to expenses and everything. My lords, the point that is to be noted that what the show cause notice, the improved notice, my lords, would find at page 54. Notice that para 2, the provisions that we are seeing just at the moment that we had highlighted to my lords, that it is as per section 61, that is scrutiny was taken. It comes at para 2, the very first line. Following that too, at page 57, at para 5. Come at page 57, para
Yes.
5.
Well, it says that it appears that there is an unreconciled ITC amounting to such and such figure, 19 crores, as reflected in 9C of the said notice. The notice is liable to reverse the wrongly availed and utilized ITC amounting to 19 crores so and so under section 50 and the provisions of GST. Well, this unreconciled ITC appearing in table 14 was an optional table during that relevant period. That period of 2017-18 to which this SCN pertains to, that a table was optional, and that table was optional in the subsequent years as well. So not furnishing of data was never an issue. But even before that, it is a wrongly assumption of jurisdiction to issue this note. Also come at page 133, the government that this was an optional table that is clearly discernible from the instructions with table 9C.
Page number
Page 133, my lord, annexure 6.
133.
That is from where it begins. The relevant portion, my lord, is the instructions to fill up the table is at page 138. It begins from page 138. 133, my lord, is the annexure from where it begins. 138 is from where the instructions to fill up the table begins. My lord, the relevant portion is at page 141. My lord, the first column relates to table number. We are here for table number. My lord, will come to table 14, which is at the bottom. My lord, at page 141. My lord, at the fifth from the bottom, table 14. My lord, should see the last line. For FY 2017, 18, 18, 19, 19, 20, 20, 21, the registered person shall have an option to not fill this table. But this is a board circular, this is a board instruction. They were anyways bound by this, asking me to reverse on the basis of non-furnishing of returns or non-furnishing of information in this table was clearly conflict.
What are the information required on the table 14?
No, table 14 is for expenses. Will come, I'll just show you GSTR 9C. GSTR 9. No, that's a page 121.
Yeah. 9C.
9C. Table 14, my lords, comes at page 125. It is the expenses that have been incurred. It's at the bottom. Reconciliation of ITC declared in GSTR 9 annual letter with ITC availed on expenses as per audited financial statement or books of account. This information was completely optional.
This was not filled up.
This was not filled up because this was optional, as we have seen at that being. The instructions for GSTR 9C clearly state that for this particular year and as also for the subsequent period, this was an optional.
This is 17-18.
This is 17. To begin with, this was a non-issue to begin with. However, because of an assumption of jurisdiction, it has been completely an arbitrary exercise of power, or rather an excessive exercise of power.
And where are the instructions?
Instruction, my lord. Instruction is at page 141. It begins at page 133. The portion of instruction begins at page 138. The relevant portion is at 141. This table 14. Last line.
Okay. And what is the stand of the state?
As per the interim order, as we have seen, they have also
So
admitted.
they filed their counter.
They have filed their counter, my lords. But then the counter also, they have not given any explanation why GST SMT 10 was not issued. They have skirted away from the issue that it was a wrong assumption of jurisdiction. They have instead harped on the fact that whether an SC and whether there is an alternate remedy, but my lord knows that an alternate remedy is not a bar when jurisdiction has been challenged. My lord, the Supreme Court has always stated it, it's a fundamental principle of law. Instead, my lord, at one point in the counter, they have also stated that furnishing of information in table 14 was mandatory, which is clearly contrary to the notification circular and the instructions that have been. So it is an incorrect government to begin with.
They say that the
Sorry, my lord.
para 23, they say it is not a demand, it's not a confirmation for demand. 187.
My lord,
right?
yeah, 187. My lord, we have clearly seen it is a demand. That a notice ultimately culminates into a demand. A notice proposes a
They
demand.
say it is not a demand.
But there is no other provision for demand. When there is a notice, in the event I don't furnish, it ultimately the amount confirms it is the demand. It is a wrong government, my lord. My lord knows this.
Yes.
Lordship, the fact that there is an alternative remedy available and we have given 5 opportunities to them for personal hearing.
You
But-
come to page number 187, para 23 of your affidavit.
At 186, at para 21, the point that my lord, I was mentioning that condition of information under table 14 is mandatory. They make an incorrect assumption, government. Coupled with the fact, my lord, that in the interim order, they have admitted that there is no GST SMT 10 issue. Whereas, my lords, in the notice, you can clearly see that this entire proceeding is pursuant to a scrutiny. My lord, scrutiny again leads us back to section 61, where the word of the law is absolutely clear that in cases of scrutiny, ASMT 10 has to be issued. The statute uses the word shall, which means mandated. But like my learned friend is saying that alternate remedy is not a bar when jurisdiction has been challenged.
Yes. Where is Mr. K?
He's on late payment.
Right. We'll keep it on 23rd.
Not to keep it on 25th, 23rd is budget, man, 25th is possible.
Then,
I on board.
then let it be on. Second of July, 2nd of August.
Second of all. The Friday hearing day, will that be, should
No,
not be a
we have hearing days on Tuesday and Thursday.
second is a Friday, man. That is why I was pointing it out. Apology. I'm gonna have it on first in that.
2nd of August.
2nd of August, man, is Friday as per the
Oh,
fact.
okay. First of all.
My lord, sir, keep it high on board, my lord.
Yes, yes. You make a mention if required.
Okay.
Matter has been heard at some time. It's first of August. Matter to be treated as part of it. Yes.
Interim orders continue.
Interim orders passed will continue. You give your name.
Hello.
The court
My lord,
marker.
if possible, if it can be taken up at 2, if Mr. Kayal is available, it's a short issue, my lord.
We have a reference today. We don't see closing the matter today.
Much of.
Yes, who appears for the respondent there?
Item number 6, I tender my sincere apologies, my lord. When the matter was called, I was not present, my lord. There was some
We were told there was some emergency you had left.
personal difficulty of mine.
Yes, we had adjourned the matter.
Apologies, my lord.
Yes, item number 42, anyone appears?
My lord, this matter is represented by BTC Council along with the Advocate General, my
So
lord.
is it
So
still alive?
I don't know. I tried to get the information from Mr. Bora, my lord. He's not picking up the phone. Probably he's like on some other phone.
All right. Then, okay. Please inform him.
Yes, I'm trying to. But
Yes, next. cycle level at this known project. Yes, have you received any information? Okay.
क्या है ये तो